Thank you, Your Honor. This is a plaintiff's motion to enter a docket control order in this case. Normally, this would be something, that we would be able to reach just by an agreement. We tried to reach an agreement with the defendants here, and they've told us that they don't want to confer on this because they filed a motion to transfer venue, and they wanted to have that heard and ruled on before we discussed a docket control order. That motion to transfer venue was filed September 30th. They haven't set it for a hearing, and I don't know why they've decided not to set it for a hearing, but our position is that it's meritless to begin with, and we just want a docket control order entered so that we can get going on this case.
All right, Mr. Wong.
Good morning, Your Honor. Our argument is that this accident occurred in Denton County. The investigating officer lives in Denton County, and so venue is proper in Denton County. And so we do not believe our motion to transfer is meritless. This case and everything that indicates all the actions that gave rise to this case occurred in Denton County. And so we believe that the facts of this case merit a motion to transfer venue.
Okay, well, we're not here on that because you haven't set it for hearing. We're here on the motion to enter the scheduling order. What's your response to that motion?
We are opposed because our motion hasn't been heard. We could set it for a hearing after this hearing. So we're opposed at this moment.
Why haven't you set it?
I'm not entirely sure why it has not been set. I was told to just argue this issue at this hearing rather than setting it for a separate hearing.
Okay, well, that answer doesn't really make a lot of sense. The motion, I guess, Mr. Taylor, anything else in final rebuttal?
I think they should set their motion to transfer venue for a hearing. If like they said, at this point, it's been 2 months. We can't just wait around for them to set their motion for hearing. We want to get this case going. We believe venue is proper here. And we need a docket control order in place to really get started in discovery.
Okay. And I assume there's a trial date in the proposed order?
There is, and these are all just dates that I picked. They haven't, given me any alternative dates, and so I don't know if those dates, work for the court, but I have a trial date on there of August 11th. That was just one that I proposed.
Okay, Mr. Wong, any issue with the proposed trial date?
No, we do not.
Okay, all right. Well, the court is going to grant the motion to enter the DCO, and Mr. Wong, it's up to you or your law firm to set your motion for hearing. I don't hear motions that aren't set, that aren't noticed on the docket. Okay, so that all of your arguments are for some other date and time.
Understood, Your Honor. I apologize.
Okay, no worries. Just want to be clear. We have local rules that require notice of hearing, so we don't hear things that aren't properly set and noticed on the docket.
Okay,
y'all are free to go.
Thank you so much, Your Honor.
Take care.
Have a good day. Thank you.
Thank you.
And Your Honor, if I may, I think it'll save us some time. I looked at the plaintiff's motion to compel, and I think we'll be able to comply with this without any objection to it.
Okay, well, let me hear from Mr. Flores. He's gone to the trouble of filing his motion, setting it, noticing it, and the time to confer and reach agreements was before today, certainly. Go ahead, Mr.
Understood.
Flores.
Yeah, so just as background, defendant was on a Zoom call at the time of the wreck, and I want the name of the people who were on the Zoom call with the defendant. This is a 3-car collision involved. The defendant, Ms. Richter, is in the back. She hits Mr. Reber, who then hits my client, Mr. Acosta. Defendant Richter has denied or is not accepting fault in this case. She's alleging fault against a stalled vehicle, maybe Mr. Richter and maybe Mr. Acosta. It's a bit unclear. But she testified she was on a Zoom call, and I want the names of the people she was on, the names and contact information of the names of the people who were on the call with her. They're people with knowledge of relevant facts. And I'm extremely frustrated by hearing this now, and I would actually ask the court for sanctions as they may deem fit. for me having to file this motion and be here now that defense counsel has agreed to this.
All right, well, let me hear from Ms. Yamron.
Your Honor, sanctions were never requested in the motion, so I would say that that's not an issue before this court. We originally, well, I guess we're sitting here today, we're agreeing to produce that information. That's all I have to say.
Okay, all right, Mr. Flores, what about that? Does the motion on file and set for today not actually have a request for sanctions?
It doesn't have a request for sanctions. All I would say is that the court has the authority to sanction when it relates to abuses of discovery. These are people with knowledge of relevant facts. I did ask for, they did allege a vague privacy theory. And when I asked for some backing of that, provided none. This is actually the second motion to compel I had to file. The last one did get partially resolved. And so, yes, sanctions is not before the court, and Your Honor can do of course, whatever she wants with that.
Absolutely. Okay. All right. Well, for today, I'm not going to impose any sanctions. However, I will state that in the future, that certainly is an option that might be granted. And I really do think all lawyers have an obligation. You'll need to work out these discovery disputes, and coming in on the day of a hearing and saying, oh, we agree, that is not the way things should be done. And it's really not an efficient use of the court's time, because we do have a lot of other matters to be tending to. So when you can't agree, you need to do it before you're doing it on my time. So I'll
Understood. I apologize, Your Honor.
Okay. All right. Y'all are free to go.
Thank you, Your Honor.
Thank you.
I'm on the next one, so
Oh, okay.
stick around.
Anthony versus Wimberley Investments et al. I think that was Mr. Newman.
Yes.
It's on the other side.
Yes.
All right, Mr. Newman, if you would turn on your video for us.
My apologies, Your Honor. Sorry, I didn't realize that I hadn't done that yet.
No worries.
Your Honor, there are two motions before the court right now. There's plaintiff's motion to conclusively establish negligence of the defendant driver. And then there's also a motion for continuance that was filed by the defense. This is a commercial vehicle crash at a four-way stop sign. Our client was taking a left and was T-boned by the commercial vehicle. So basically this case is a lot of our word against the defendant driver's word. And our client was noticed to testify at deposition. He showed up to his deposition, he testified, and he gave his side of the story. And the defendant driver has been noticed for deposition twice, and he has essentially fled the case. Ms. Yamron, I know her office has made extensive efforts to get a hold of the defendant driver, but they have not been able to do so, and he has essentially fled the case. And so we are asking the court to grant to conclusively establish that he's negligent under 215.2 because he's had two opportunities to appear at deposition to tell his story, and he has not, and he has basically evaded those notices and those opportunities to tell his story. And the court has authority to do this under 215.2. It says that anytime a party does not comply with a discovery request, the court can conclusively establish an ultimate fact. And of course, the punishment has to fit the crime here. And he has twice not given his story, which is essential for trial. And this case is set for trial on January 27th. So, Your Honor, we ask that the court conclusively establish negligence of the defendant driver.
All right, Ms. Yamron.
Well, Your Honor, we filed our motion to continue the trial first, and so I'd ask that that be ruled on prior to the plaintiff's motion, which was filed subsequently.
Okay, well, that's fine. Are you going to argue them at the same time, though?
I just think that some of the issues contained in our motion to continue the trial are relevant as to the plaintiff's arguments. I would like to have that heard first, as it was filed first.
Okay.
And noticed before the court first.
I don't have an issue with that. Mr. Newman?
Yes, Your Honor. Oh, I'm sorry. No, I don't have an issue with that either, Your Honor. And if Your Honor, Miss Yamron filed the motion, so I guess she can argue that.
Okay. Go ahead, Ms. Yamron, on the continuance.
Sure. Your Honor, we filed this motion to continue the trial. We have been attempting to get depositions since June. I believe that there should be some email correspondence attached to our motion to continue trial. We do have a little bit of an issue with communication with our client at this time. Initially, at the beginning of the case, we've answered discovery, we've complied with everything in any way. And we are having we have a private investigator out looking for him. This is a dispute in terms of liability. There was never a motion to compel Mr. Russell's deposition by Mr. Newman. The first there was only one notice of non-appearance on the file, and I don't think that Mr. Russell has violated any court orders to warrant any 512 sanctions. In this case, plaintiffs' attorneys, when they have difficulty finding their clients, have the benefit of being able to dismiss their case. At this, we don't have the benefit of doing that. And I think that we are in the process. And as Mr. Newman has said, we are trying to find him. We have a private investigator, representative for the van, the corporate owner of the vehicle, proceeded yesterday. And, he came to the scene, he spoke with our client, and this is a liability dispute case. So we would like an opportunity to continue the trial on that basis. Furthermore, mediation has not proceeded, and that is required by the rules, unless there's unless the court allows it not to proceed. So we do not have a mediation set on the books that has not proceeded. Furthermore, we have outstanding subpoenas for medical records, and it has been past the time allotted for them to comply. And so we need to get a motion to compel on file to get those medical records. Plaintiff's attorney is claiming $2 million here in this case. And so, for those reasons alone, we are requesting that the trial be continued in this case.
All right, Mr. Newman.
Yes, Your Honor. I'll start with the subpoenas. This is the first time that I'm hearing about subpoenas of medical records. Have not heard about it throughout the entire case. There's no evidence in the record of that. And I have not heard anything about subpoenas to medical providers. And in fact, it's my practice to let pretty much all subpoenas to medical providers go and not file any objections because I think they're entitled to it. So to the extent that they sent subpoenas directly to the medical providers, too late in the game to get them, I don't think that's grounds for a continuance, and we have not halted those efforts at all. Next, Your Honor, mediation. We've agreed on a mediator, Bruce Clark. Bruce Clark also, of course, Clark Mediation has Debbie Clark. They have the capacity to mediate the case, in the next month or so. And if they can't do it, somebody else can do it. But we still have about 50 days before trial or something like that. So we can certainly get a mediation on the books before the trial setting. And so that's also something that has not been cited as any kind of concern for the need for a continuance. And then on the certificate of non-appearance, Your Honor, and some of these technicalities that they're pointing to, there's no requirement that we put a certificate of non-appearance on file. We just have to provide the court evidence that they wouldn't show up to the deposition. And in the record, there are 2 emails from opposing counsel that in the days before the deposition or the day before the deposition saying our client will not attend. So there was no need to get a certificate of appearance because we have that evidence right there in the record. And then as for the court order, 215 does not require a court order or a motion to compel. If the defendant driver didn't show up to 2 depositions, why would he comply with a motion to compel? I don't think it's necessary to waste the court's time with a motion to compel after the defendant driver has refused to follow the rules, refused to communicate with his own attorney, and essentially fled the case. So there's and that's why the rules say that this sanction or this conclusive finding of an ultimate fact can be ordered by the court without a violation of a court order and with a violation of a discovery request. And Your Honor, to grant a continuance in this case would tell defendants everywhere that, hey, all you got to do is not show up for deposition and not comply, and you can get your case moved in Travis County and have the case continue. Where we would be essentially rewarding the defendant driver for not showing up to his deposition and not complying with the rules. I think that sets a terrible precedent. This is not a motion at all against Ms. Yamron or the defendant driver's attorneys or anything like that. This is a motion against the defendant because the defendant is not complying with the rules. And we set this case for trial pretty far out from when we filed it in order to secure a top slot on the docket to make sure that this case goes to trial. And if we had to continue this trial, both Ms. Yamron and I have we have a lot of trials. We both try a lot of cases, and there are a number of expert witnesses in this case, treaters really, and we would have to. We've gone to great lengths to get everybody ready for this trial setting. To reset it and have to close all those loops again, get dates from everybody, and move around everybody's calendars. I don't think it's fair to do that because the defendant wouldn't show up for his deposition. And yes, Your Honor. So that's all of our arguments on those points.
Okay. Ms.
Your Honor, may I
Yes, briefly.
Your Honor, this trial or this complaint in this case, or the petition, was filed on September of 2023. So this case is a little bit older than a year old. The plaintiff has disclosed 3 expert witnesses. None of those depositions have been scheduled. I think it's very disingenuous of the plaintiff's attorney to attempt to say that, we're purposely not presenting a client for a deposition because of, him disappearing. Plaintiff's attorneys file motions to continue all the time, and they're routinely granted. And you know what happens during that time? They come up with new information, new discovery. And we're not doing this in any purposeful manner, but we don't have a mediation date set. I have not agreed to use Miss Clark. I think we had agreed at one point, but we don't have a mediation set that is required by the court. We would like an attempt to find our client. We don't have the benefit, as I said before, of the plaintiff's attorney of being able to dismiss our case when we have lost our client. And so it is extremely prejudicial for us not to be able to have our client available. Clients do, in fact, listen to court orders and judges when they are required to do something. So we would like the opportunity to find our client, have him be present, participate in a deposition. I don't know why Mr. Newman says that he was not aware of subpoenas, because he was included on those and they were filed by the court. So he had notice of these subpoenas. So I don't know where that came from. But I think that it would be extremely prejudicial to proceed with this trial, given the circumstances of this case. And I would ask that the court grant the motion to continue.
Your Honor, may I briefly respond for about 15 seconds?
Yes.
Okay. So as for the expert depositions, they have had notice of our treating providers since this case was filed, and they had the opportunity to take those depositions from the very beginning, and they, to this date, have not requested those depositions. We did not even expect that those depositions were going to be taken. We're not going to take those depots. We're going to call the treating pain management doctor live at trial. This trial is probably going to have 4 or 5 witnesses, and we're going to be able to put our own entire case in chief on probably just in one day. So we haven't received any requests for those depositions since they've had notice of the treaters since last September of 23. And on the point of the subpoenas, yes, Your Honor, we knew about the subpoenas. We got notice of the subpoenas, but what we did not get notice of was that there was some kind of a concern that could potentially delay things or delay the need for delay the trial. That's something that we haven't heard anything about. There's been no conferencing on it. We have not filed any objections to any subpoenas. There's nothing on our end that's holding that side of the process up.
And then, Your Honor, though he has retained experts that are beyond treaters. So him saying about anything about the treaters, he retained experts from Houston and Dallas that are not treaters. So that is new information, and I would like to bring the court's attention to that because I feel like he was trying to skirt around that issue.
No, I'm sorry, I didn't mean to do that. We have designated 2 retained expert witnesses.
Yep.
But we have received no request to depose those expert witnesses, and there's still time. I mean, we can still present those expert witnesses for trial. We still have a whole month of discovery left, and we can make those experts available anytime. There's no need to delay the trial over that. And we all agreed to these expert witness designation deadlines together. And so there has been no request to depose them, but if they want to depose them, they can in the next 30 days, and we'll make them available.
All right, I've got questions. When were the subpoenas sent? Ms. Yamron?
Yeah, bear with me, Your Honor.
Okay. And when were the new experts designated or disclosed?
They were designated and disclosed timely, Your Honor, and I'm pulling up the exact date for the court right now.
Your Honor, ours were, the subpoenas were sent out there were 2 sets. The plaintiff's deposition did not proceed until October. So that was another issue. We had been requesting the plaintiff's deposition so that I could get information regarding his prior medical history since June. And due to family-related issues on the plaintiff's side, he was not able to present his client until a month and a half ago. So one set of subpoenas were sent in July, and the other one was sent, looks like, in early November because of the delay and being able to get the plaintiff's deposition set.
Okay, I asked 2 questions. I'm still
Yeah,
waiting.
so the 2 questions are, one was in July, one was after the plaintiff's deposition for his treating physicians in November.
All right, and the date on the new experts?
Yes, Your Honor, that date was November 12th. And that was, so the reason why it was November 12th and not the original date on the scheduling order, which I believe was like November 2nd or something like that, was because Ms. Yamron requested extra time to designate experts, and I gave her that extra time. And then, I also had extra, I think 10 extra days or something like that to designate. So those were all agreed upon. And then, yeah, so that answers the court's question. I could address Ms. Yamron's other arguments, but I'll wait for the court to.
I'm just gonna, am I allowed to
Y'all
share
are-
my screen? Am I allowed to share my
running
screen?
up against your 15 minutes, okay?
Sorry.
So let me do the talking. Have you talked to the court admin about what line number you are?
Your Honor, I have spoken to Mr. Bavra a while back. I know that we're ranked very high. I looked at the future settings report pretty recently, and I'm almost 100% sure we're going to get reached based on where we are. I don't know the exact number, the exact line number that we are right now, but I am very confident that we're going to be reached.
All right. And last question, Ms. Yamron, when was the last time you heard from your client?
I want to say, let me just pull up I know it was during the summer because that's when we were trying to schedule depositions. Let me pull up. Looks like we last heard from him in July. I know that according to our corporate rep that he went back to California to assist his parents that were sick. So my understanding that he has returned to Austin, and so we have an investigator finding him at this time.
All right, here's what I'm going to do. I will grant a continuance of 90 days. And y'all can confer about what trial date works for you and contact court admin to get a new date on the calendar. as far as the motion for establishing negligence by the failure of defendant to appear, I'm going to deny it without prejudice, and I'm going to order that defendant appear for a deposition within the next 45 days. So y'all confer on what that date is, but I will sign an order requiring him to appear. If he does not appear, then this issue might be ripe for discussion some other time down the road. But I will say, obviously, Mr. Newman, if you may plead yourself into a situation where the defendant no longer has insurance coverage because of a failure to cooperate, and you might want to consider that very carefully. But
Have,
that's
Your Honor.
that's what I'll do for today.
I have. And also, just to respond to that, they've already conceded that he was in the course and scope of employment, and they represent the company that he was working for. So that's why that's not a concern for us. And Your Honor, a quick question. So the continuance, is the continuance 90 days from the current trial date, or is it 90 days? Like, does that trial need to be set 90 days from now, which would be, about, I guess, like 40 or 50 days from the current trial setting?
Well, 90 days from the trial date is what I intended. I mean, you could try and set it for earlier by agreement, but Mr. Newman, you'd get a very not a good line number if you did. So I think you're going to both of you will want to confer with the court admin about when you're likely to be reached for a new date.
And Your Honor, so we have the ability we can set it before that 90-day mark. Is that correct? And just talk
only by agreement. Okay. Parties can do whatever they want by agreement, typically.
Right. But what my concern is that, okay, 90-day continuance, is that the first available setting after 90 days after the trial date? Or is that saying that this trial must be tried within 90 days from the original trial setting? That's just, and the reason I'm asking is because, we've been working hard to get this case ready, and we're ready to go. And so I just don't want to get into a situation where, we're having to push this thing 6 months down the road because they wouldn't show up for their deposition.
I'm not sure what the confusion is, but a 90-day continuance means that the January 27th trial date is continued, and it will be reset after 90 days have expired from that date.
Your Honor, would you like me to prepare an order? And if so, should I send it to?
It can be emailed
Mr. Woodby?
To staff. Yes, Mr. Woodby would be fine.
Okay.
Please circulate it as to form before you present it to the court.
Okay. Thank you, Your Honor.
All right. Thank y'all so much. You're excused. Have a great weekend.
Thank you, Your Honor.
Thank you. You as well. I'll see you next week. See you on Tuesday.
Oh, okay. Take care. Matter of the marriage of Boudoir. Go ahead and make your appearances.
Kelly Burris for petitioner Ajay Boudoir.
Jake Gilbreth for Jennifer Boudoir.
All right. And we're here on a motion to enter and a motion to vacate an arbitration award. Is that correct?
Right. Yes, ma'am.
Okay. What are we taking up first?
I would think sorry, Ms. Burris, I would think the motion to vacate, because if that's overruled, then the motion entry, essentially that's the barrier to the motion entry. I think I emailed Ms. Burris about just one issue on the decree she sent to the court. But the form of it matches the arbitrations award and the mediated settlement agreement. But we would have to have the motion to vacate ruled on first before I can sign off onto the decree as form.
And Your Honor, our argument is their motion to vacate really has nothing to do with the final decree. We have a September 4th award from Mr. Pittman on all drafting disputes that the motion to vacate doesn't have anything to do with that. And so they haven't submitted any revisions to the final decree that I haven't agreed with. The motion to vacate has only to do with this one June 17th, 2024 arbitration award out of 4 that only deals with 1 week of summer possession from June of 2023. So I don't see how the June of 2023 arbitration award that they're asking to vacate has anything at all to do with the decree.
Well, I guess it comes to which one you want to take up first, but on the
let's-
entry, I believe that's the barrier to me signing off onto the form. And Ms. Burris still has the decree as being as agreed as a form and substance by the clients, and they wouldn't sign it because it's based off of both the mediated settlement agreement and arbitrations that were arbitration awards that were issued. So I don't think they'd be signing the decree. But that's the only revision as far as the entry is I can't have my client sign it as agreed.
Okay. All right. Well, Mr. Gilbreth, go ahead and tell me more about the motion to vacate.
It's largely contained in our motion. So there was a dispute about summer that the parties had. Their mediated settlement agreement has language about the summer in it that essentially says that there's a 1 week and a 1 week with one parent getting the first week of the summer in even years and the other parent having the first week in the summer in odd years. And essentially that causes a situation, I won't go into too many details, but essentially causes a situation where there's a 3-week block. It's the issues kind of all set forth in the arbitrator's award, which is attached actually to our motion as Exhibit B. I think Mr. Pittman essentially, our interpretation is that we think rewrote portions of the summer, which then dovetailed into what is in the divorce decree, and that concerns me as far as having my client sign off on it or agree to the divorce decree. We think that dovetails into the arbitration awards that he issued in September. And so to make sure that our record is clear, and so it's to clear that we didn't agree with the arbitration, we did file a motion to vacate. That we had brought that up, I think, before. If you remember, we were up in front of you on the school issues, because this mediated settlement agreement has a lot of gaps in it, if you recall. Kind of the same issue where we couldn't enter the decree at that time until that motion to vacate had been ruled upon. We actually tried, me and Ms. Burris were in front on the family law docket trying to get the decree entered and the same issue ruled on, but you had a docket note, essentially what I guess us in the court interpreted as this needs to come back to you on it. But I think a lot of it is sort of protecting the record, and if there's future modifications, protecting things that are said about my client and whether or not what she did agree to and didn't agree to. Also contained in the motion to vacate, and it's actually set forth in Mr. Pittman's award as well, is that my client's counsel, which wasn't me at the time, my client's counsel was actually not available. Miss Badgett Clemens essentially had COVID, and another lawyer from her firm had to show up, which my client felt prejudiced her in the hearing and that it should have been continued. And it wasn't. This minute issue was arbitrated by Mr. Pittman. So we would respectfully request the court to vacate that award. Ms. Burris's point may be fair that's it kind of renders it moot given Mr. Pittman's further arbitrations, but we need that cleaned up and that ruled on. And like I said, as far as the divorce decree itself,
Understood. All right, Ms. Burris, you can respond on the motion.
Yeah, Your Honor, yes, Your Honor, if you'll bear with me for just a minute, I'm going to try to go through some of the timeline because we're requesting fees today. So it's going to take me some time to get through a little bit of this timeline because of all of the ins and outs of this and the constant delay. The parties reached this mediated settlement, the MSA, on November 2nd, 2023. So over a year ago, it settled all of the child-related matters and most of the property matters in this case. And then the parties agreed to arbitrate the few remaining property matters. Mr. Pittman arbitrated those issues and issued an award on December 12th and a clarification on December 18th. The MSA agreed that Mr. Pittman would resolve all drafting issues. Since that time, Ms. Bodwar has changed counsel twice, and the parties have scheduled 5 arbitrations to attempt to resolve language disputes to get this matter resolved. We had trouble even getting the first arbitration scheduled because of her change of counsel. Once we did, the arbitrator canceled that first setting. However, we rescheduled for May 16th of 2024. When everyone showed up to that morning, Ms. Bodwar insisted we cancel the arbitration despite her attorney at the time being present and everyone else being present and ready to go because she wanted to take more time to review the red lines in the decree. That this all could have been done May 16th. However, at the time, there was an issue with that 1 week of summer possession from June of 2024, where the parties were disagreeing on the interpretation of the language in the MSA for that summer possession. And we needed to get clarification on that language for that 1 week so the parties would know who would have possession and the child wasn't, I don't know, standing out on a street corner for that week. Because of the urgency, we rescheduled the arbitration for June 17th, 2024. At that arbitration, Ms. Bodwar's assigned attorney, as Mr. Gilbreth said, was not able to appear. She had COVID. However, another attorney from their office, Raven Brown, appeared. And Mr. Pittman heard argument from both attorneys regarding the language in the MSA for that 1 week. Because we had to figure that issue out, Mr. Pittman resolved the 1 week of possession based on how he'd likely rule on a drafting dispute over the language in the MSA. But he left open until a full arbitration could be held on making any award on how that language would be drafted in the decree. I believe that letter is in their attached to their motion, but I also would offer that letter or that arbitration award as P4 into the record if there's no objection. I think.
Not an objection.
Okay. So I'd offer P4. This is the June 17th arbitration award, which they're now filing their motion to vacate. In that award, Mr. Pittman was very clear in the first and the last paragraph that that all other drafting disputes were reserved for another time. And in part 4 on page 2, he specifically says he's not making an award on the language in the decree, but only telegraphing how he would like early rules so the parties might be open to reaching some other agreement. I'd also like to add that this award in June favored my client actually getting the entire week, but because my client was agreeable to splitting that time just to resolve the issue, they split that time. So if the court were to vacate the arbitration award, how the language ended up coming out in the September 4th, he would have actually gotten that entire week. So regardless, the summer of 2024, long past, their motion is entirely moot. The one issue that was ruled upon was simply how that 1 week would be treated. That's it. And everything else was reserved. All drafting disputes, as I mentioned, everything else was reserved. After that arbitration, we again met with significant delay in resolving this case after June 17th. I attempted to reschedule arbitration, but our counsel at the time never confirmed the 4th mediation date, presumably because she was changing counsel again. I filed a motion to enter, or in the alternative, to order the parties to arbitration on August 2nd. We had a hearing before you on August 14th on my motion to enter and their motion for clarification. And at that time, they hadn't filed anything regarding this June 17th ruling or award. At that hearing, you ordered us to arbitration on the 28th and granted the divorce and entered the MSA and the arbitration awards as a judgment. My second point related to their motion is that because you granted the divorce and rendered judgment, that time is passed to argue any arbitrations awards prior to that time. And again, even if their motion wasn't totally moot, it's too late to challenge the arbitration award at this point. Mr. Pittman heard argument on every drafting dispute at the August 28th arbitration, including the language regarding the summer possession schedule that had been addressed in June. So he reheard all of this in August. He also allowed both parties an extension to review and submit further argument up to September 4th. Nothing related to that June 17th award was submitted by that September 4th date. He went ahead and issued a full arbitration decision and award over the language in the decree on September 4th. This award resolved all drafting disputes and attached the final decree in sufficiently the same form that I submitted it to the court. I made one change that they had requested, and then we had also agreed to give Mr. Bodwar credit for support payments made directly through October. Those were the only changes I've made to the arbitration award submitted and filed with the court by Mr. Pittman. They filed their motion to vacate arbitration award on September 13th, disputing only that June 17th award. And again, as Mr. Gilbreth mentioned, we were also here on September 27th to clarify the 14th ruling. A motion had been filed to date, disputing the decision and award on September 4th. They haven't said anything about that September 4th award, which resolves all drafting issues. There's been additional delay even getting this heard. After they filed their motion to vacate, I sent an email requesting dates to set my amended motion to enter the decree because we couldn't get them to sign it on October 8th. No response. I sent a follow-up email requesting dates on October 15th. No response. I set my notice my motion for October 30th. Still nothing from their office. It wasn't until Friday afternoon, October 25th, that they asked us to agree to have my 30th setting. They either hear their motion to vacate first or continue my setting. Both parties showed up for that hearing on October 30th, and that's when Judge Arth set any additional motions in front of the court that we're here for today. Even after all that time, I still I still haven't received an explanation how any ruling on your part on that motion would change the draft of the decree I want the court to enter, or even what they really expect to accomplish with their motion to vacate. It has nothing to do with the language in the decree, as I mentioned. And again, they haven't even told me what the drafting dispute really is. Your Honor, I've been trying to get this final decree entered in this case for nearly a year. It's been one thing after another, and I'm requesting today that the court just stop the ongoing issues and delay and enter the final decree of divorce. I'm happy I can submit another version with the agreed taken out, or the court can write it in. However, whatever we need to do to get this decree signed today. I'm also requesting attorney's fees in the amount of $4,000, and would like to prove up fees.
Okay, and are those requested in a motion or in a response?
They're in our motion to enter. We requested attorney's fees.
Okay. I see Mr. Gilbreth has something to say.
Well, I have a lot to say about the presentation. First of all, on fees, which I can go through the timeline why I think fees would be absolutely inappropriate on this. If for no other reason, the mediated settlement agreement, and I wasn't counsel there when they agreed to it, reserved so many things for arbitration that caused significant delay. I wasn't there. Ms. Burris was part of that mediated settlement agreement. It's not surprising, though, that that's dovetailed to so many problems in this case. They haven't produced any invoices on fees. I don't see they have them uploaded as exhibits, but they haven't produced them to me. And I think under the Rormorse case, that would preclude them from fees. I don't think I can sign off on a divorce decree because that would conclude the case while there's pending a motion to vacate an arbitration award, which I do think is important for that to be ruled on. And if it's overruled, it's overruled, but that protects my essentially timeline of the case. When we were in front of you in August, we had the same conversation. We said, well, technically, I'm still within my time period to file the arbitration, so we really can't go forward with the motion to enter right now. Council all agreed. You agreed. We did timely file that motion to vacate. We've been seeking to get that ruled upon, including when we were all here at final trial, final trial for the motion to enter and the motion to vacate in front of Judge Arth, where he essentially said, no, this needs to go in front of Judge Mangrum. So these folks, when they agreed to essentially reserve so many things for arbitration, it did dovetail into they don't agree on a lot of what they agreed to. And they did have to arbitrate issues. And we do think that Mr. Pittman should have continued the arbitration in June. We do think that dovetailed into issues in the arbitration award that he issued that's in front of you. And we do think that I think that I can't sign off on a divorce decree or the motion to enter until my motion to vacate is ruled upon. I've been clear with Ms. Burris with that. When she and I had the conversation in front of you in August, that was the conversation about procedurally the way we need to proceed. When we were both up here at the courthouse, and Judge Arth, frankly, to our surprise, said, no, this needs to go in front of Judge Mangrum. Me and Ms. Burris were trying to get all this set. And if Ms. Burris will recall, when we went down the hall, I said, you email Judge Mangrum's court and ask if we can do it by Zoom, and I'll just make myself available for it, right? Because it does need to get resolved. But I think that the motion to arbitrate or the motion to vacate needs to be ruled upon first. That's been an issue since August. I think the fees request is inappropriate given the history and that they haven't produced invoices on it. I do think it does need to be resolved, though. They need a final divorce decree.
Sure. Okay. Ms. Burris, I'm going to ask you to be as brief as possible. I'm going to let you know y'all have used 12 of your 30 minutes already. And if you want some time, assuming we get to the next motion, keep that in mind. All right.
Yes, Your Honor. Just, I did submit attorney's fees, my fee agreement, and my billing statements as petitioners, I think 6 and 7. Would ask that to be admitted into the record and call myself as a witness for attorney.
Any objection to those exhibits?
I would object. I don't believe they were produced.
Ms. Burris?
Well, I submitted them in the box link, and the attorney's fees discovery is done. We've got a mediated settlement agreement. We've got an arbitration award. Nobody's supplemented anything because we have these things that have been ruled upon. I mean, everything has been a judgment since then. I mean, the court entered a judgment and granted the decree August 14th. So really, we're just here on motion to enter and attorney's fees and this motion to vacate.
Well, I didn't supplement because I'm not asking for fees, right? So I didn't supplement my fees. But to the extent that they're saying for fees, they're essentially saying it's an ongoing case. You can't have it both ways, right? Either it's over or it's not over. If it's not over and they're asking for fees and they should have produced really 30 days out from trial, they should have produced their fees.
There is not a trial setting.
Well, there's this setting.
Right.
I'll sustain the objections. You may proceed with the testimony. Do you swear or affirm the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Go ahead.
I do think, I guess, two things for the record. One, obviously, I stipulate the qualifications and reasonableness of rates. But I do think, for the record, I have to object to the testimony because I don't think you can ask for attorney's fees without invoices under the Rohrmorse case. And I don't think it's an appropriate testimony. But the expert hasn't produced, she's essentially testifying as an expert. And if the documents on which the expert relies upon or have been reviewed as a basis of her opinion haven't been produced, then I don't think the expert testimony that Ms. Burris is offering is appropriate. It's the same argument with regard to the invoices.
All right, Ms. Burris.
Your Honor, again, there's not a discovery request with respect to this motion to enter. It's I can testify as to attorney's fees, and I've submitted attorney's fees statements. And matter of fact, my attorney's fees statements were up through the last setting were submitted to opposing counsel and to the court as of October 30th. They were uploaded and submitted as of that October 30th hearing. The only thing, and additionally, I can't, I can't do it 30 days in advance if most of my fees are coming within the last 30 days.
So the invoices, but the same issue with the invoices. So I think the testimony follows the same objection with the invoices. As regard to them saying there's not a discovery request on this specific motion, I have a pending request for disclosure on this case that would cover that. Also, it was filed in 2021, which I believe the old disclosure rules would be in place.
All right, I do think that the Supreme Court of Texas has made it clear that invoices are required for attorney's fees testimony.
And they were submitted to the court for the October 30th setting, as well as opposing counsel for that October 30th setting. And then I uploaded them today or yesterday. Actually, I uploaded them by I think noon yesterday into the box link that's accessible to all parties that are opposing counsel, the court, in our office.
So I don't believe they were produced. Uploading it to the box when we were told to go away that day. I didn't see invoices in there. We were told to go away on that day. They weren't produced. The court sustained the objection to invoices, so I just had to assert the same objection on the testimony. Having already given my speech as to why I don't think fees would be appropriate in this anyway, given the history.
Okay. I'm going to deny the request for fees. Y'all have used 17 of your 30 minutes. Based on, I mean, Mr. Gilbreth, you know what the legal standard is for arbitration awards, and I haven't heard anything here today that leads me to believe you're anywhere near that standard. So I don't know if you have any final words on the motion to vacate.
I don't have any final words because I made my arguments. I think procedurally the court would overrule because technically they actually never sought for the court to approve the arbitration, but it's all baked in, right? So I think you would need to overrule the motion to vacate, and then once Ms. Burris removes the agreed as to form and contents, or you could cross it out. But if she could send that to me, if the court overrules the motion to vacate, then we can sign the divorce decree and submit it to you within the next hour.
Okay. Yes, I'm going to deny the motion to vacate, overrule, however you want me to put it, but the arbitrator's award ruling stand. And then that takes us to the motion to enter. And I think what you're telling me, Mr. Gilbreth, is the decree can be entered, but it's not agreed as to form.
Yes, ma'am. My two suggestions, Ms. Burris, which I think I heard her say she agrees, is it's first of all, it's titled Agreed Final Decree of Divorce. It's probably better to title it Final Decree of Divorce. It does have correct recitations in it, though, later on, where it talks about how this is based on both agreement and arbitrations. But I think you would remove the word agreed final decree, from the final decree of divorce, and then at the very end, where it says approved as to form in substance by the parties. I don't think that they'd be signing off on it, given that some of the decrees based, I don't think they would be signing off on it as to agreed, since some of it's based on arbitration decisions.
All right, Ms. Burris.
Your Honor, I'm fine with those revisions. I actually made them while we were waiting to be heard, so can submit that to the court. My only clarification on it is, are we okay with, as far as appearances, just saying the parties appeared through in person and through attorney of record and announced ready? And are we deleting all of the signature lines for the parties and just doing as to form for the attorneys?
I agree with that. If Ms. Burris doesn't mind making those edits, then we'll sign off on it. Or I guess it'd just be me signing off on it. I can do that this morning.
Great. Ms. Burris, if you can do that, and we need the BVS form as well.
And Your Honor, if I could ask for a note, in the event they don't sign it today, if we could submit it to the court and just have the court sign it by submission. I just don't want any more delays.
Sure, that's fine. I mean, email it to Mr. Woodby. I'll sign it whenever I get it.
Okay,
So,
thank you, Your Honor.
all right. Thanks for your patience, and seeing nothing else, y'all are free to go. Have a great weekend.
Thank you.
Thank you, ma'am.
Take care.
You too.
Then why don't you go ahead and restate your appearances? All right, that's good.
Your Honor, Nicolette Rivera Modesto, attorney for the petitioner, Mr. Juan Martinez.
Your Honor, Dulce Ravago, attorney for Michael Castro, respondent.
Okay, and we're here today on the motion to enter.
Yes, Your
correct.
Honor, it's a bit of an unconventional motion to enter.
Yes. Okay. Well, why don't you tell me what the disagreements are and what you need the court to decide?
So, Judge, hopefully you remember this case from I think maybe your second month on the bench. And this is a divorce with two minor children. The court ordered the parties were divorced at the time of the hearing, initiated and issued all of the child-related orders at that hearing, and then reserved the property issues because we did not have a valuation done on the community business. We did not have values for the community properties in the United States. You needed more information before you could make a ruling. Instead, you ordered that the properties have the business appraised and that the parties come up with a spreadsheet of the property values, and you ordered the sale of all the properties in Mexico. My client I'm just going to give you kind of a rundown and then I'll make arguments. So we have gotten now to this point where we have a business valuation. We have a real estate agent in Mexico, and we are now needing from you, Judge, a percentage division on how to divide this property. So that's why I said it's kind of an unconventional motion to enter, because we don't know property division at this point. And so from you, Your Honor, what we need is just for you to tell us how you want the property divided, 50-50, 60-40. You did find the divorce granted on the grounds of adultery and cruelty against my client. So that's where we are now. We both have spreadsheets. They are going to be, from my perspective, kind of impossible to reconcile. On Miss Castro Martinez's spreadsheet, she has separate property that belongs to my client under community property. She has enforcement claims that she has brought that Judge De La Yata has already denied. She's requesting to keep property that you have already ordered to be sold. My client has done all of the work and all of the heavy lifting to get us to this point. And so my request of you, Judge, is that you just tell us what percentage of division the parties are going to get so that we can reconcile these spreadsheets and be done.
Okay. Let's see, Ms. Ravago, you want to go ahead and respond?
Yes, Your Honor, and I'll try to not be repetitive, just to add a few things. I would say that I submitted a property division proposal. Of course, as counsel said, we're probably not going to agree on a lot of the items. And yes, Maite did request, as opposed to the sale of the property, instead the division of the properties, especially the ones in Mexico that are several, because at this point, for whatever the reason is, the parties haven't been able to sell this property for the last since January 2023, and without excusing, my client, I did enter in this case June 2024 of this year, July, something like that. So she proposed that we put in that property division sheet a division of the property, so each party keeps certain properties as opposed to the sale, so that we can get this divorce wrapped up and get a final order. I know also counsel mentioned that we made recently enforcement requests from the court. Yes, we did, especially because the court reserved, as Attorney Reyes said, several issues, took them under advisement and ruled from the bench on other. Within those issues where the child support amount, because I also uploaded the transcript, and the court did state that the court petitioner will pay child support we don't have an amount. There was no reference made as to spousal support other than that. I'll rule on other issues later on when we have a complete picture of the financials. And also we were requesting 50% of the unreimbursed, which was actually granted by the court. And we submitted receipt for those out of pocket expenses that might pay for the children's doctor appointments and so on. With that also, in our spreadsheet, I tried to make it simple, and I highlighted the items that from our perspective, we don't have enough documentation to support the amounts, such as the properties that petitioner is keeping, such as the accounts, his amounts, right? The checking or credit, whatever the account is. For example, some loan statements that were missing from vehicles, regarding EFF wholesale, the court also requested that financial records were produced from petitioners. We have none of those records or financial documents. And also regarding the business, we do have a business evaluation, and I highlighted that portion because, again, as counsel already mentioned, we don't know what the court is going to decide on that for the division of that item. And one moment, yeah, I'm just making sure I'm not seeing. And yes, and so along with that property division sheet, I did upload supporting documents for the amounts we have in the spreadsheet. We did request other items from opposing counsel. They did produce several documents, but we still have we do believe we're missing financial information for some of them. For some of them, we agreed, and I guess we submitted all the documentation we have. We highlighted the items for the amounts we disagree, and we're asking for the court to give us some guidance of what the court wanted to do in regards to child support amounts, spousal support, at least, because the idea of my getting spousal support prior to the final hearing was so that she was able to keep up with the expenses. And so far, she is deep in debt because I know this is not the party's too long to get to a final decree order, but that's where we're at now. That's why we kind of need some guidance as to whether or not the court wanted to grant post-spousal support. What was the amount of child support, so that we're requesting it to be retroactive to January 2023 when the final hearing had place. And I think that's it from us for now, Your Honor.
Okay. All right, Ms. Modesto, I don't know if you want to respond briefly to some of those issues.
I do, Your Honor. The issue of going back, retroactive child support, all of that. You did order child support, and Mr. Martinez has been paying guideline maximum child support. He makes over the maximum amount and has been paying the max that the court could order him outside of extraneous circumstances, which the court did not find at the time of the hearing. So I believe Your Honor has already addressed child support in the prior order. The court also did not order spousal support or special maintenance at the prior hearing, and simply said the only issues reserved were property division. So I do not believe that you need to go through that as well, nor are there any motions on file before you today. The only thing before you today is this motion to enter. I do believe Ms. Rabago and I can come to an agreement about numbers in terms of what is in checking accounts and stuff, because that's very easy to do, and we've got the statements for it. So the only big issues on our spreadsheet is whether or not his separate property that they have listed is in fact separate or community, and the confirmation that any enforcement claims will not be or should not be included in this spreadsheet because it's not part of property division, and then what the percentage is for the division.
All right, and Ms. Modesto, as far as what you are referring to, his separate property, did the court already make a ruling finding that at the prior trial?
You did, Your Honor. At that hearing, you found that any property that he had inherited or received from his father's estate was his separate property. And my client has a very clear memory of you saying that.
Okay, and you have the transcript available?
I have the transcript of your ruling, Your Honor. I don't have the full transcript of the hearing. This was just an issue that came up yesterday because we noticed it was on their spreadsheet as community property.
Okay. So, Mr. Rabago, we're here on a motion to enter. We're not here on a motion to reconsider. So the things that the court has already ruled on, those are done. I'm not we're not relitigating those here today. So I want to make sure that is clear.
Understood.
Okay, so
Yeah.
for the division of property, as far as the percentage, based on the finding of adultery and cruelty, I will do a split, and the respondent, Ms. Castro, will be awarded 51% of the community estate. Mr. Martinez will be awarded 49%. Okay, so that is the number that will apply to all of the community, which is included on the spreadsheet. The court already set child support as guideline. We're not relitigating that today, okay? So you already know what that is. What else do we need to talk about in order to get the decree entered?
I think that's it, Your Honor. I'm happy to, I have a draft of the decree, just needed those numbers. I'm happy to finalize that and send it over to them for approval.
All right, Mr. Rebecca, is there anything else?
Your Honor, just to clarify, yeah, we were not asking for enforcement and clarification. We just wanted to make sure that if anything was awarded to her in January 2023, that to make it retroactive to that date. If nothing, we understand, Your Honor. And I was going to mention just regarding the highlighted items we have in our property division sheet. We're limited to those items. Those items are the items that we disagree because we don't have enough supporting documentation. And last, regarding the property that it's been claimed as separate or inheritance from father to petitioner. We also just wanted to let the court know that we uploaded documents that are contracts for purchase of those property during the marriage for both of those properties.
Okay. Last time I'll say it, these issues were already determined. You tried the case and you had the documents you had or you didn't have at the time. The court has made rulings on those. We need to get the decree entered. If you have some post-entry relief that you want to seek, that is up to you or your client. But decisions were made based on the evidence that was presented at the trial, and you don't get to come back years down the road and say, oh, we didn't have good evidence of this or that, or we want better evidence of this and that. Y'all set the case, y'all tried it, you tried it with what you had at the time, and decisions were made based on the evidence that you did or didn't have at the time. And now people have to live with that. So.
Yes, Your Honor.
Okay. Do y'all have the BVS form, and can you send that in with the decree?
We can, Your Honor. Absolutely.
Great. If you could send that to Mr. Woodby, I would appreciate it.
I will begin working on that, Your Honor. Thank you.
Okay, great. All right. Well, seeing nothing else, I will excuse everyone from the virtual courtroom. Thanks so much.